This is Barry Zalma, speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we'll speak about why representing yourself in a court or an appeal is foolish, and why a convicted felon incompetently sought shortened sentence in a pro se pleading before an appellate court was simply and totally a waste of time of the defendant and the court. Rameeza S. Chowdhury appealed as her own attorney from the order dismissing her petition pursuant to the Post-Conviction Relief Act, the PCRA, and must serve the full sentence. In a case entitled Commonwealth of Pennsylvania versus Chowdhury, an August 8, 2024 decision of the Superior Court of Pennsylvania, Chowdhury's attempt to get out of jail was found to have been made without an appropriate basis and incompetently. Everything arose from a situation where an entity called Berks Psychiatry, a medical office headed by Doctor Mohammed Khan, resulted in the arrest and conviction of Ms. Chowdhury. Before her arrest, the Commonwealth received information that patients could walk into Berks Psychiatry and receive prescriptions for certain controlled substances with little, if any, medical examination. A search warrant was executed on October 16, 2012, resulting in the seizure of numerous records and approximately $7 million in cash. Dr. Khan unlawfully prescribed approximately 145,000 pills from January 1 of 2012 until December 16 of 2012. Chowdhury, BP's office manager, was charged as an accomplice to Dr. Khan with respect to prescribing 3 controlled substances, Xanax, Adderall, and Ritalin. In addition, the Commonwealth filed several charges particular to Chowdhury as a principal, which encompassed fraudulent billing, racketeering, perjury, and hindering prosecution. Medicare would be billed for separate visits on a different dates, that is, one day with the therapist and one day with Dr. Khan, when really the patients saw both persons on the same day, if at all. Several BP witnesses testified that it was Chowdhury who ordered the alterations in the record keeping. After a non-jury trial on March 8 of 2017, the trial court convicted Chowdhury of 3 counts of unlawful administration of a controlled substance by a practitioner, 2 counts of corrupt organizations, and 1 count each of conspiracy, perjury, insurance fraud, and hindering prosecution. The trial court sentenced Chowdhury to an aggregate term of 6 to 18 years of imprisonment, to be followed by 2 years of probation. Chowdhury did not appeal her conviction. On June 6, 2019, Chowdhury timely filed a pro se PCRA petition, her first. Chowdhury presented the following 2 questions for consideration by the appellate court. 1. Whether Chowdhury is guilty by association for drug crimes when she was employed by a medical doctor as an office manager. And 2. Whether the Commonwealth met its burden of proof in overcoming the protections of statutes which confer additional immunity from guilt by association for those good faith office manager employees of medical professionals who were convicted of drug crimes incidental to government overreach, subject to counsel review. Chowdhury argued that she is not guilty as a matter of law, because as office manager she performed administrative duties and had nothing to do with drug crimes. Couched within the first issue, Chowdhury also argued that the Commonwealth did not prove she constructively possessed drugs because office managers do not dispense drugs. Chowdhury concluded without expounding that counsel missed this law and its immunizing effect ineffectively, and therefore her verdict should be and her sentence should be reduced. The appellate court concluded that no relief was due on any of Chowdhury's claims. First, Chowdhury failed to raise these issues in her PCRA petition. Accordingly, all of Chowdhury's issues were waived on this basis. The appellate court noted that a petitioner cannot raise issues in a PCRA petition that had been previously litigated or waived. Chowdhury's claims all center around her argument that she cannot be held criminally liable because she was merely an office manager who worked under the direction of Dr. Khan, which was previously litigated on direct appeal. Chowdhury's claims were, therefore, ineligible for PCRA relief. To establish an ineffective of counsel claim, a petitioner must prove 1. The underlying claim had arguable merit, 2. No reasonable basis existed for counsel's actions or failure to act, and 3. The appellant suffered prejudice as a result of counsel's errors, such that there is a reasonable probability that the result of the proceeding would have been different absent such error. However, because Chowdhury did not develop this issue, let alone prove the inadequacy, the appellate court concluded it was also waived. In my opinion, it is axiomatic that the person who represents herself in court has a fool for a client, and is a foolish litigator to take on such a difficult task without appropriate training and experience. Chowdhury failed totally, made an enemy of a court-appointed lawyer who withdrew, and then totally failed in her attempt to represent herself to the appellate court, proving the axiom correct. The crime she and her employer, Dr. Khan, committed was evil rather than medicinal, and she will now serve the sentence of 6 to 18 years in prison at the desire of the state and Commonwealth of Pennsylvania. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 4,850 blog posts. You can also subscribe to the videos on rumble.com and youtube.com. They're free. And please tell your friends and colleagues about these blogs so that they too can subscribe to either the blog and or the videos. If you're interested in further detail, please consider subscribing for a very small fee to my Substack publication, Excellence in Insurance Claims. Thank you for your attention.